mediation, and then there's a negotiation, and then there's a conciliation. So conciliation and negotiation, obviously, I understand that you guys must have a lot of competitions in respect of negotiation competition which is going on. But I'll be very honest, in practical real scenarios, negotiation happens very less. I think negotiation is more of a corporate side of a law place, because obviously their deal closing happens between the two companies, two transactions happen, and their negotiation helps. However, in proper litigation side, arbitration and mediation are two different aspects of ADR, which is very prominent. Now, ADR, obviously, arbitration we'll talk about, but what is mediation? So, mediation, and the difference between arbitration and mediation is, in arbitration, advocate plays a very important role. Like, we as an advocate plays very important role, wherein we understand the case of a client, and then we eventually represent it before the arbitrator. However, in the mediation, advocate's role is little less. It's all between the party, and then there's a mediator. So mediator basically asks the parties to tell what their dispute is. He tries to settle down between the terms of the dispute with plus minus from both sides, and then he eventually tries to resolve the dispute. So the role of advocates are pretty less in mediation, whereas the role of our advocates are much higher in arbitration. Obviously, what are the dispute resolution hierarchy? So if you read a construction contract, so obviously there are a lot of things which, wherein there are different steps by which disputes has to be resolved. So first is negotiation, wherein the parties, between the two construction parties, they eventually directly try to negotiate between each other, and they try to resolve it. Then there's mediation, wherein obviously the mediation, which I told you, that there's a mediator who is trying to settle down the dispute between the parties. There's a process of conciliation, adjudication. Adjudication is very limited in recognized in India, because obviously adjudication happens by dispute resolution board, and that board is basically a step prior to what arbitration is. In case if DAB, like dispute adjudication board, it's known as DAB. In case if that is not sufficient and the party is not happy with the dispute and the solution that the DAB has provided, then obviously the party moves to arbitration, and then it moves to litigation. Correct? Now, let's come to what is arbitration. So, I hope, guys, you are there. Please, can anyone say something? No one can say?
Yes, sir.
Okay. So, what is arbitration? Arbitration, as someone from you only have stated everything, she was absolutely correct in what she said. Obviously, there are few additions to it, which I'll tell you. So, arbitration is an form of an alternate dispute resolution, wherein parties agree, both the parties agree for a neutral arbitrator to decide. Now, why arbitration happens is because it is little private, it is confidential. Still in India, most of the arbitrations are private, and until unless it reaches the stage of a court, till then, that time, obviously, all the arbitration remains very confidential. Now, this is very efficient and very time flexible to the parties, because at the end of the day, in an year or maybe two after taking section 29 into, like, after extension of the arbitration, the parties know that their dispute will be resolved. Other than, in comparison, on the contrary, in the court, we all know that day to date things happen, and in year, almost like two to thrice, twice or thrice, the court matter is being heard. So court litigation is time taking. Arbitration is a very less time taking process, so parties are opting more for it. Now uh, now have how many of you have been to an arbitration proceeding before? um I want, just give me a second. I want to see you guys also. How can I do that? Uh, just give me a second, yeah. Mm. Anyway, in the meanwhile, can you please guys answer, like, how many of you have been to an arbitration proceeding before? Anyone? I'll go this way only. I don't know how it is. Yeah. So anyone can answer? How many of you have gone to arbitration before? No one has gone to an arbitration hearing. Hello, I need
Yes,
responses.
sir.
We
Anyone has gone to an arbitration proceeding before? I don't know. Do you guys can hear me, right?
Yes, sir.
Okay. Anyway, I mean, it's okay if you haven't, so you can say a no also to it. That's fine. I mean, we are pretty chill about it, so you guys can take a very little less tension about it. Anyway, so basically, this is what arbitration proceeding room looks like. Can you see my cursor?
Yes,
Yes,
sir.
sir.
Okay. So I'll tell you. Now, this side, if you see my cursor, this is a party A sitting. Okay. And then on the opposite party B sits. Correct? Then this is a tribunal who is sitting. Okay, it might be a sole tribunal, like this person might be a sole tribunal, or it might be a panel of tribunal. So basically three arbitrators. Okay, then this madam sitting here is the typist. Like there's a stenographer who sits in a arbitration, because obviously the order has to be dictated, and then in cross examination the transcript has to be made. So this person is a stenographer. Then there are legal researchers to the arbitrators if arbitrators require. So basically they are the, I mean, maybe person who is interning with that judge, or maybe person who is assisting that arbitrator. So these are the people who are assisting these arbitrators. So like in the front portion arbitrator sits, and then obviously parallelly, like on the opposite sides to each other, facing each other, parties sit. Correct? Everyone is with me in this?
Yes, sir.
Yes,
Yes,
sir.
sir.
Now, what is history of arbitration? Obviously, arbitration, as we all know, that is an unsectoral model. So it started pre-independence era. Then, I mean, I won't focus on this a lot, because obviously in India right now, what I want to tell you guys is that 1996 Act prevails. I mean, there was a 1940 Act also, which you might hear in a lot of judgments, which you might hear in a lot of cases. But that 1940 Act is gone now. In India right now is 1996 Act, which was amended in 2015 and also in 2019. So this slide is little old, which we need to update. Anyway, so what are arbitration advantages? I've already discussed that this is very confidential, efficiency and speed. Now this has an expertise also. Expertise as in, because obviously the person who is sitting as an arbitrator, he knows the topic well. So in arbitration, the best thing is that the parties choose their own arbitrator. So it's the good thing that they choose that person only who they feel that is a very has an expert in that area. So it's like one party to, in case of a sole arbitrator, obviously both parties decide and go with one name. But in case of a panel, obviously one party chooses one arbitrator, other party nominates the other one, and then eventually both the arbitrators who are nominated by each party goes for a presiding arbitrator, who is the main head. Now it's very flexible, because obviously party chooses their own time when the arbitration has to be done, how much time pleadings have to be resolved. So it's a very flexible kind of a thing. Now, how many types of arbitrations are there? There are two types of arbitration: domestic arbitration, international commercial arbitration. So, domestic arbitrations are those arbitration which are based in India, not based in India. I mean, the parties are of India. International commercial arbitration is that arbitration which is like in one party is of foreign and one party is of India. There is also a concept of foreign award which I have not put in this slide, but I want you guys to know that foreign award is an award which is not based in India. However, it might be that one of the parties is India, is of India, and therefore that award has to be executed in India. But that award is passed in like maybe in Singapore, Hong Kong, or any place outside, maybe London. So it's that thing. Now let's understand what is an arbitration process. Okay, can you guys see this slide? I mean, it's little small, but are you guys able to read what is there?
Yes, sir.
Okay, so this is very important, like what is arbitration process, and this is in respect of a construction arbitration only. Okay, so obviously there's a step one, which is a tender stage. Tender stage is where party A and party B both sign a tender. Both, I mean, tender is opened by a party A, who is the employer, and then obviously everyone bids for that, and then once who is the lowest bidder, they get the contract. So obviously a contract is executed between party A and party B. Like let's take hypothetical example to explain you guys this. Party A and party B is like two parties who have been in the stage of tender, and they initially start with the work. Okay. Now once the tender is final, once the bidder is final, once the work is being set to given to party B, then comes the agreement stage, wherein party A and party B signs a construction agreement between each other, that what type of work has to be done, in what time it has to be done, and like different payment clauses, different term sheets, at what duration this project has to be done. So everything happens in that agreement stage. Now in during the process of the project, obviously there are differences, and then dispute occurs between the parties. Then obviously then there is step 4, wherein there is a notice invoking arbitration. Now once dispute arises, then obviously the parties might be party A or party B, whosoever is facing the dispute, who is a sufferer, they raises that we want to go for arbitration. So they send a notice invoking arbitration. Once notice invoking arbitration is sent, then the other side accepts that notice invoking arbitration, and arbitration starts. Now, the first step of how arbitration starts is the constitution of an arbitral tribunal. So, firstly, the arbitral tribunal has to be executed. Like it has to be formed, whether it be a sole arbitrator or a panel of arbitrator, as I explained you, that depends. Now, once the tribunal has been formed, then obviously there's a completion of pleading. So in arbitration, pleadings are basically statement of claim, statement of defense, rejoinder, etc., etc. So all those pleadings are being completed. Then in step 7, there is framing of issues. Like once the pleadings are being formed, once the dispute is there before the arbitrators, like this is the dispute between party A and party B, then they frame issues, like on what issues they will adjudicate upon, and then they will decide and hear the parties are going forward. Next step is obviously about the evidence and cross examination, where the parties submit their witnesses, and then cross examination takes place. After that, final arguments take place. Both the parties and the counsels argue for at length, like what their case is. And once everything is done, the final award is being passed by the arbitral tribunal. Anyone has any doubt in any of the states, please ask me.
So could you please explain the step number first again, the bidding one?
Okay, so bidding one, I'll explain in more detail this time. So basically, what happens in a construction contract is, like for example, National Highway Authority of India. Let's take example NHAI. Okay, they want to construct a road from Delhi to Gurgaon. Okay, so they will issue a tender wherein they will invite all the participants, all the companies who basically construct road to bid for that tender, wherein they ask ki how much amount you can build this road from Delhi to Gurgaon. Now the companies who wants to bid, take up that work, they bid for it. Like for example, one says I build this road from 100 crores, other will say 150, other will say 200. So whosoever is the lowest bidder, they that party, obviously everyone wants to pay less. Okay, so NHAI basically chooses the lowest bidder. Okay, for example, L&T says that I'll complete this road in 100 crores, and JMC says like no, I'll complete it in 120 crores. So NHAI will come up and say, okay, L&T, you have chosen 100 crores, you are being the lowest bidder, so therefore I'll give this award to you, and you please complete work for Delhi to Gurgaon. So this is the tender stage wherein work is being awarded to a company. So NHAI here being the employer because they are awarding the work, and L&T here being the employee because they are taking up the work that they will execute a road between the Delhi to Gurgaon. So this is tender stage. Now, next stage is agreement stage. So once L&T is being final, then NHAI and L&T will sign an agreement between each other, wherein agreement would say that the scope of work will be to construct road from Delhi to Gurgaon. So this is how the thing works. Understood?
Yes, sir. So
I,
also step first necessary arbitration में कोई केस जाने के लिए can a independent contractor that ऐसे ही a party A and party B instead of just bidding came and form a contract, so can they include that arbitration clause in their contract?
Yes, obviously. I mean, see, I was giving this example because this presentation is about construction arbitration. Like in normal arbitration, other than construction arbitration, who are working together. Like for example, party A is like Google, and then party B is like an employee who is like Ayush. So in case an agreement is between Google and Ayush, wherein obviously the in case everything works well and I'm doing their work, everything goes off is good. However, in case of any dispute, then that dispute will be resolved by arbitration. So in that state, directly the stage of finalizing, I mean, constitution of arbitral tribunal will come. There's nothing, all these step 1 to 4 will not be involved in that. It's just because we are doing construction arbitration, therefore this tender stage and everything comes into play.
Yes,
Understood?
sir. Yes, sir.
Anyone else? I think anyone was else had also had a doubt.
Yes, so
Yes, sir. Could
I
you
had
also explain the step 6? Could you give example for the like current scenario, the construction arbitration you said? What sort of pleadings can we see in this stage? Step 6.
So, like for example, I'll again come to this NHAI and LNT only. So, for example, tribunal is being constituted and Ayush is the arbitrator here. So now Ayush will ask LNT, NHAI being the claimant and LNT being the respondent. So claimant Ayush will ask NHAI to file statement of claim. Statement of claim is basically termed as SOC. So statement of claim contains basically, it's basically a type of a petition only. Petition, like petitioner files a petition. So claimant files a statement of claim wherein they basically put everything, like what all claims they have against LNT. Now, once statement of claim is filed, then the other side as a written statement. In arbitration, there is a term statement of defense. So other side will file statement of defense. Once statement of defense is filed, then NHI will again get a chance to reply to that statement of defense, and then they will file a rejoinder. So basically, statement of claim, statement of defense, and rejoinder. These three are types of pleading. Now, eventually, there might be a scenario wherein LNT would say, no, no, why would only NHI have a claim? I would also like to have a claim. So they will file a counter claim. And then same statement of counter claim, then a reply to statement of counter claim, and then rejoinder to a counter claim. So arbitration basically works in a parallel way. Statement of claim, statement of defense, rejoinder, statement of counter claims, reply to statement of counter claim, and rejoinder. So these are the types of pleading which arbitration has. Understood? Or anything else you have to ask in this?
Yes, sir. Understood. Thank you.
uh, Anyone else has a doubt? I think there were people. No,
yes,
can I?
so I
Yeah.
had a doubt regarding constitution of arbitral award, basically the tribunal. So during the constitution of the arbitral tribunal, if both parties agree on arbitration,
i
but
want listen to what people are saying. I'm so sorry, I'm putting it. Yeah, you can say.
yes, sir, am I audible?
Yeah, you can. You are audible.
Yes, sir, I had a doubt regarding arbitral tribunal.
Hmm.
Basically, if both the parties agree on arbitration but disagree on who should be the arbitrator, so basically, what is the most time efficient way to resolve that deadlock?
So basically, when a party sends a notice invoking arbitration, in that letter only they mention, like, we are appointing Mr. Ayush as our arbitrator. In case if you want to have your own arbitrator, so you just let us know. And they mention a timeline also in that. So timeline maybe 30 days or something like that. In case in those 30 days the other side didn't does not come up with any arbitrator name, then obviously the other side who wants to start with arbitration, they have a right of section 11. So they go before the court, they file a section 11, and then obviously then how much time section 11 takes to resolve. I mean, that is completely depend on court. Like in Delhi High Court, section 11 gets resolved very early. In Bombay High Court also it gets resolved very early. Like nowadays, so Supreme Court has said that section 11 should also be completed within 60 days. So I assume, like, in case if parties agree between each other, 30 days is a time limit. However, in case if the process goes to a court, then also it has to be resolved within 60 days. Understood?
Yes, sir.
Okay. Mm, let me start again. I'm so sorry, guys. I'm a little tech, not a tech savvy. Okay, where's the presentation? Yeah, understood. Anyone else has a doubt in all these step 1 to step 10? I, I think no. Okay. Now, next slide is what happens after award is passed. So once the award is passed, like if you see the 10 step is the final award. Okay. So once this award is being passed, obviously there are two choices. Either whatever the award is, like award is basically a type of a judgment only. So whatever the judgment is, parties accept that and pay whatever award is being awarded. Second is challenge the award. Okay. Now I'll move to what are key sections of Arbitration Act. So obviously we all know that every act has a lot of sections, huh? But obviously we understand that there are few very star sections which are very important for each of individual who is practicing in that area to remember. So arbitration also is a very beautiful act. Huh? I would suggest everyone to read arbitration in case if you haven't, and I would suggest everyone to try and go into an arbitration, like real arbitration also, so that at least you can understand what arbitration is all about. It is a very small bare act with a very small, like very cute sections, so that at least obviously everyone will understand. And then it has its own plus, it has its own minus, but eventually once you fall in love with arbitration, you will love it. Like I'm a person who has fallen in love with arbitration. Okay, so I'll just run through a few important sections. Everyone, I believe, should note down these sections so that at least whenever they go for an internship or later on in life, these sections will play a very pivotal role in their journey. So section 7 is arbitration agreement. I mean, everything starts in an arbitration act with an arbitration agreement. So section 7 talks about what arbitration agreement is. Then section 9 is interim measure by the court. Section 9 is basically, because obviously section, if you see section 11, section 11 is the stage wherein appointment of arbitrator is there. Like I was just answering, like in case if the party doesn't appoint an arbitrator, then the other party can go to court. Now, the other party can go to court under Section 11 of Arbitration Act for appointment of arbitrator. However, because this duration takes time, in the meanwhile, if any interim measure a party wants to seek, then they can file a Section 9 petition before a court, and then they can file an interim relief. Obviously, if you read Section 9, then there are various clauses, and then there are various reasons. I'm not dwelling into that because obviously it's a very time taking process. But if you read Section 9, so you will see which conditions, I mean, the court can allow in an interim measure for. Section 11 is appointment of arbitrator. Section 16 is competence of an arbitral tribunal. Like in case if a party says no, this tribunal is not correct, I want to challenge this tribunal, I want to say that. Obviously, in case if you know in litigation, there's a lot of cases where territorial jurisdiction comes into play. So exactly same, like if a party wants to challenge the competency of a tribunal, they can file a Section 16 application before the arbitral tribunal only. Now, similar to Section 9, because obviously this interim measure were by court, Section 17 talks of interim measure by the tribunal. Section 27 is from where the arbitration proceeding starts, like the pleading stage, which I was just discussing. Then Section 29A comes into play, which is like extension of arbitration. So Section 29A basically says that the arbitration has to be resolved in 1 year. However, it says if a party wants to extend, it can extend it by 6 months. Again, it says like after 1 year, 6 months, if again that arbitration is not over, then again the parties can go to a court under Section 29A, and they can request the court to extend the timeline for the arbitration proceeding. So it depends on at what stage arbitration proceedings are. Timelines are being extended by 6 months or a year. So basically, in 2.5 years, this arbitration, all arbitration get resolved. Now, Section 31 is form and content of arbitral award. So obviously, once the arbitral award is passed, so arbitral award also has its type. Like type as in how it has to be. It has to be in a very reasoned award, a very well written, in a very well written form, so that a layman can also understand it. Now, here I said no. Option 2 is challenge the award. Now, under which section you can challenge the award? Under Section 34, a party who is not happy with the arbitration award can go and challenge it before the court. Now, Section 36 is enforcement of an arbitral award. Enforcement basically means, like, for example, if a party gains an arbitration award and 90 days time period to challenge the award goes off, then obviously that party will want now this award should be executed, should be enforced. Therefore, they can again go to a high court. I mean, they can go to a court and they can apply for a Section 36 application, wherein they can they will ask the court to enforce this award so that at least whatever award is being passed, it can be deemed come out as a court decree. Any doubt in these sections?
No, sir.
No, sir.
Okay. Okay. Now, what are recent developments in Arbitration Act? Because I told you that in 1996 Act is there, but it was like amended in 2015 and then in 2019. So then in 2019 there was issue on arbitration fee, which is settled like obviously Schedule 4 has come up wherein we have to go and in an ad hoc arbitration we have to stick by what arbitral fee the tribunal has to be getting. Then there are constitution of arbitral institutions like ICA, DIAC, MCIA. These are the arbitral institutions who are organizing arbitrations for the party so that everything works in a very proper manner. Then timeline for conclusion of arbitration proceeding, Section 29A, which just I discussed. And then there's a formulation of Arbitration Council of India. It is yet in the like on the paper stage, but it is yet to form. Okay, now comes the main topic, construction arbitration. So I asked initially, like, how many of you know what arbitration is? Now I'll ask you, how many of you know what construction arbitration is? Anyone? Any answer? Say yes or no so that at least we can quickly run through it.
No, sir.
No means what? You don't know, you don't have anything. Anyone? I think no one must have heard it, but anyway. So basically, construction arbitration is like in India, we know that there is like, you know, on the roads that we walk, on the trains that we travel, on the flights that we take from an airport. So in India, obviously, for every building that we sit and for every facility that we use, construction happens. So basic of construction arbitration is like for all the roads, metros, railway stations, airports, ports, then the buildings that is being constructed by a builder, all these things, anywhere where construction is happening in India, that comes under the umbrella of construction arbitration. So basically, construction arbitration in India is a cornerstone of non-development, contributing significant national GDP and representing one of the fastest growing sector. Okay. Now, what are the key characteristics? Now, construction arbitration, obviously, there's a multi-party involvement. Multi-party involvement means कि obviously one I told you about NHI and LNT. Now, for example, LNT constructs a road, but in that road construction, they wanted to apply a steel barricading towards the corner of the road. So for that steel, they will contact JSW. Okay, so this is the multi-party appointment. That will be a subcontractor. So basically, NHAI comes, then LNT comes, and then JSW comes for its own work. So every party who has its own scope comes into play for a construction, and therefore matters happen, disputes happen between different parties. Therefore, construction arbitration is a very multi-party involvement. Now, extended performance period, obviously, extended performance period means, like, for example, NHAI says that from road from Delhi to Gurgaon, it has to be constructed by LNT in 6 months. However, LNT, because of XYZ reasons, it couldn't do in 6 months and it didn't work in 12 months. So, therefore, there was an extension. So, in that extension, obviously, there are different claims, there are different disputes. We will be talking about those in the slides below, but this is involved. Now, then there's a technical complexity. Technical complexity is basically because obviously for the construction of roads and everything, you need technicalities. Like, for example, one of the matters which I was doing, it was a thermal power plant project wherein thermal power plant has to be constructed. So, in that technical complexity of how much moisture content a coal should have also comes into play for generating an electricity. This technical, these construction arbitration can get into. So in case if anyone wanted to be an engineer when they passed their 12th, however they landed up in law, this construction arbitration field basically gives you a chance to be an engineer plus a lawyer. I wanted to do engineering because I did my 12th from science background. However, I ended up in law because I have a phobia of maths. And therefore, eventually things happened, and eventually when I'm working in construction, I'm going back again to that engineering background. So basically, a civil engineer plus a lawyer is a person who would do construction arbitration. Okay, so all those who wanted to do engineering, there's a scope still exist. Anyway, substantial financial implications comes into play, obviously, because obviously there are a lot of risk. Like in case if a NHI gives work to L&T, however, after some time L&T feels like they don't want to do this work and they terminate the contract agreement. So obviously there's a risk of who will do the work then. So these risk allocations happens. Now there is regulatory compliance, because obviously, I mean, NHAI, LNT, all these things happen, but at the end of the day, they are governed by central government. So in case supposedly BJP says no, 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 now roads will be constructed not by cement but from a bituminous cement. So entire process of collecting cement and a bituminous cement, there's a difference. So entire thing of regulatory compliance comes into play, and then L&T might have to give them with a changed rate or have a different variation to it. Understood? Anyone has a doubt? No doubts? Okay. Now, next is common sources of construction dispute. Now, there is a contract formation and interpretation of issues. So, obviously, as I told you, that in a construction arbitration, agreement is being formed, and then that agreement is the god for both the parties. Now, in that agreement, if there is some ambiguities or there's a lacuna in the drafting of that terms of those agreement, then it results in the basically common, I mean, one of the dispute which might arise later on when the project is being executed. Then cost overruns and variation claims. Cost overrun basically is like what I told you, like in 6 months you have to do, but it has been completed in 12 months. So therefore that extended period of 12 months is basically cost overruns, like how much extra I paid for it. So for example, I wanted to have a JCB machine, and it was to be the work if have been completed in 6 months, my rent of JCB would have been 10 rupees. However, because it got done in 12 months, therefore again an extension of 6 months, therefore my JCB rent from 10 plus 10, that is 20 rupees. So this extra amount of 10 rupees is basically cost overruns. Then there's variation claims, like I told you, a cement was there for rupees 5, but now government says no, you have to use bituminous cement, which is on rupees 10. So this extra amount of 5 to 10 is a variation claim, and these are the examples which I'm giving you. So design changes, material cost, then currency fluctuation in international projects. Now example, my one of the client I was working with, they wanted to build a hotel in Malaysia. So obviously Malaysian currency in respect of India might be, if for example let's take 1 Malaysian rupee is 5 rupees in India. Later on, like during the pendency of the project, that 1 rupee changed into 7 rupees. So this currency fluctuation took place, and that was a difference between the things. Unforeseen site conditions is also very important, because obviously once you construct the road, you all know, like there are various rights happening, then the locals create a lot of problem for the contractor to resolve it. So these are the things which happens. Now then project delays is there, extensions is there, wherein project delays happens because of the financial problem, then force majeure like COVID comes into play, or earthquake or any weather condition comes into play. Changes in government regulation, I've already informed you. And then obviously poor management, project management, like for example, like the supply of raw material is not there. And then obviously if like raw material is there, then the person who has to work, he's not there, so there's not a better coordination between each other. So that also results in project delays. And then quality and performance dispute, obviously that for example, road was to be constructed with a very a standard of road. However, once the road was constructed in next 3 months, all the cement went off, all the stones went off, and therefore this was a very poor quality of road which was built. So this quality disputes come into play. Then how the technical specification comes, non-compliance of a technical specification means, for example, road of a cement was built, was to be built, however the contractor built a road of a mud. Therefore there was a difference between the non-compliance of what was asked and what was done. So this is the difference between the technical specifications. Are you guys understanding this?
Yes, sir.
Yes, sir.
So I just had a question.
Yeah.
Suppose that there is an agreement between party and B, and that agreement contains that arbitration clause. However, later on that agreement turns to be void. Then what is that status of arbitration clause? Like how party will settle down their disputes if it occurs later on?
You want to say that entire agreement is void?
Yes. So what will be the status of the clause?
So see, I mean, obviously, arbitration agreement is like can be part of that main agreement also, and the parties are free to execute a different arbitration agreement as well. So generally, parties execute a different arbitration agreement so that at least in cases of what you are saying, however, 99% doesn't happen because the agreement which is being formed is being vetted and then it is being executed, notarized, and everything happens in a construction arbitration, I would say. So in those cases, 99% this situation I have also not seen in my 7 years. However, in case if it happens also, then still parties have their construction arbitration, not from just the agreement, but also from the notice and working arbitration, which comes into play, the letters that they have exchanged, the kind of tender process, tender documents that they have, like the LOA which was awarded. So there are various small documents in construction arbitration which has this dispute resolution clause. And therefore, if agreement goes off, still you have a lot of documents pending with you, so that at least you can initiate an arbitration. So this is how it works.
Okay, sir.
But it is a good question, yeah. Anyway, common types of construction dispute. So let's go quickly. Delay and disruption claims. I already told you, like if there's a delay between the parties, like for example, NHAI had to construct a road. NHAI asked LNT to construct a road. However, that road where it has to be passed, that road was not awarded. Like for example, if NHI asks LNT to construct a road from X point to Y point, and in that obviously X point to Y point there might be a lot of encumbrances, like might be like there must be a lot of trees, or there must be a lot of villages might come up into that play, localities might come into play. So NHI, it's the duty of the NHI to remove all those encumbrances before handing over the site to LNT so that they can construct. However, in case if NHAI is not able to do it, then obviously there's a delay, and LNT won't be able to start the work until unless these encumbrances are being removed, and hence the delay starts. And once delay starts on the starting point, then eventually the project gets delayed till the end of the stage, and then eventually small delays keep on adding during the pendency of the project, and eventually the project gets delayed by a lot of events. Now, as I have written, that delay arises when timeline is not achieved. Disruption occurs when contractor efficiency, even if the completion date is met. Now, such claims are commonly called as by ambiguous contract terms, like contract terms, if it says like you have to start the project after 15 days of signing of the agreement. However, after 15 days in real scenario, there was no site at all. So obviously that is an ambiguous contract term. So these are the various discrepancies which come into play. Then unforeseen site conditions, which I told you, in case of like not a proper right of way which is being provided. Then force majeure events, like for example COVID, then government compliances, and then obviously earthquake, and then like a cyclone or something like that way. Then regulatory changes, like what I told you, like government can change anything anytime. So these are also one of the reasons. So these are the things. Now there are standard contracts like FIDIC, CPWT. FIDIC I will be speaking about later on in the slides. So these provide a lot of different types of techniques wherein the disputes can get before the arbitration, which I've already discussed with you guys. Next is delay claims. Delay claims I've already asked you. Like for example, types of delay I believe is better. Employer who causes the delay. Like employer, please take it as a NHI here. So late approvals, as in for example, NHI had to give approval for like removing the tree from the Ministry of Environment. However, they didn't get the approval from Ministry of Environment, so delay happened. Then design change. For example, the road had to be going from Delhi to Gurgaon through Dhola Kuan. However, it happened through Janakpuri. There was a change of design. Then delayed site access. Site access is same. Like there were villages, trees, and unfortunately, they were not removed. So encumbrances could not be removed, and therefore there was a delay. So this is employer caused delay. Then there are contractor caused delays as well, like poor performance. So obviously the quality of the road was not well. Then resource constraints, so all the manpower, machinery, there was some constraint to that, like no proper manpower was not there. For example, if the road had to be constructed by using 100 workmen, however there were only 70 at site, so obviously there's a gap of 30 workmen, so it will take some time for that 70 also to complete the work of those 30. Therefore there was a resource constraint. And in respect of manpower, and then in respect of machinery, so for example they had to comply with JCB cranes, but I mean JCB cranes were busy or were not available at the site. Therefore entire work in respect of JCB was delayed because the same machine was not there, so it could not uplift the encumbrances, and therefore the delay happened. Then obviously there are management issues, which is like more of the office politics, which we all deal with. Then there are neutral delays like force majeure event, regulatory unforeseen. Similarly, what I've told you. Then there is concurrent delay. So these concurrent delays are basically two delays happening at the same time. For example, I say, okay, for employer, it will employer NHI says that NHI will give road to LNT, and they will seek approval from the Ministry of Environment for removing those trees. So NHI failed in getting an approval from Ministry of Environment. However, in the meanwhile, L&T had to deploy its manpower. But because manpower was not there, so that same duration of time, NHAI failed to get approval and L&T failed to apply the manpower. So these two delay happened at the same duration of time. These are known as a concurrent delay. Everyone got that? Anyone has any doubt in this? Uh,
No, sir.
no. Okay. Now, suspension is basically, I mean, if the project is temporarily halted, obviously there's termination. So, suspension and termination both I'll take together because we are running out short of time also. So, suspension basically happens when the project gets halted for temporary reasons. And, like, for example, NHI says right now, for next 6 months or next 2 months, please halt the condition because, like, for in one of the cases which we are dealing with, in that we had to construct a building. However, that building was stopped because of this like, for example, in recent days in Delhi pollution, if you see, then GA4 has come up. So obviously in GA4 all the construction activities have been put on hold. So this is basically a suspension of the project, wherein for some duration of time the project gets suspended, and then eventually after that duration it again starts, and for that suspended period obviously the contractor gets an extension of time. Now termination is where the project gets completely terminated, nothing to be done again, no further steps in that, and therefore this termination comes into play. Anyone has any doubt in termination and suspension? I'm not getting into a lot of details, I'm just explaining you basic concepts so that at least once you come across these words, you are aware of what you have to say to a person. Any doubt in these?
Sir, I have a question.
Yes, tell me.
Sir, since arbitration clauses are governed by the intent of the parties, and if they have not mentioned a prescribed time limit that upon the subsequent failure of completion of the project, what extension period of the project will be done. So, can the parties refer the matter to the arbitration?
No, I'm not understood, can you please say again?
So I'm saying arbitration in the construction arbitration contract, in
Hmm.
the agreement there is no explicit mention of the completion time period of the project.
It won't be possible, it is not possible at all. Like in a construction agreement, 100% there are few ingredients, 100% that has to be resolved, otherwise that agreement is not agreement at all. So this is like next to impossible situation which you are asking me today. Like if a construction agreement has no end date, okay, so every construction agreement will have a, either that contract agreement will be valid for some time, or agreement will be like that the work has to be completed in this money time, this much time.
Yes, sir. We often see cases where in housing development corporation projects get delay for the infinite time, like 10 years, 12 years, and ultimately they refer to the arbitration. So in that case, if there is no any explicit timeline, or if the developer has exceeded the prescribed time limit, then can court interfere and award some pass some orders, despite having the construction agreement.
No, obviously, in case if see, it's like in case if a parties, obviously we know that what parties role have these days. So, in case if parties don't want to opt for arbitration, and in case if you want to go for court remedy, then they are free to go for it. So that is not important. So court can obviously apply, but that won't be an arbitration. That will be basically a civil suit then.
Uh,
So they
ex- exactly, sir. As you have earlier mentioned that there is a limited intervention under Section 11 of the arbitration. If
section
the Section 11, sir, Section 11 courts cannot interfere.
section 11 is appointment of arbitrator.
Yes, sir. So if my housing development project gets delayed for a long period of time, and I don't have any prescribed time limits, then I don't have any remedy from the courts. So court cannot grant any relief to me.
No, but court can ask you to, either approach the process of a contract which is there between the parties, or if a party wants to go for an arbitration also, then obviously, in respect of this, notice invoking arbitration has to be sent. In case if a party has sent a notice invoking arbitration, yet the other side is not responding, and it is being like, like you said that for 10 years nothing happened. So then the party who has sent a notice invoking arbitration was at a fault, because obviously you have to write how much time the other party has to respond in that period. In case if that period goes over, then the other side has always an option of going to section 11 before the appointment of arbitrator. So this is how it happens. Like, obviously it might be in housing board situation. We also need to understand what contract is there between the two parties which is happening. So this contract to contract things differ. This process is a general process, so I'm not saying that it might apply in every case you are saying. Obviously every case has its own fact, also every case has its own contract. So I don't know about housing board development. I would be happy in case if you can send me any contract of housing board development. Let me go through it. I'll read it, the contract, and then I might be able to guide you in a better way.
Exactly, sir. So the only remedy is the appointment of the arbitral tribunals if my project gets delayed.
But then for this appointment of arbitral tribunal, you have to send a notice first. So this you can't just directly go to section 11. Okay. For section 11 also, court will ask you whether you have sent a notice to the party other side or not. In case if you say no, then section 11 court will say, oh, I'm sorry, I won't be able to entertain this petition. But in case if you say yes, then the other side will say, okay, tell me where the arbitration agreement is there. Which arbitration clause are you referring? Then in that contract, court will see which arbitration clause you are referring, whether the parties can go to arbitration or not. Secondly, it will say that notice has been sent, and then it will appoint an arbitrator. So for appointment of arbitration also, there are prerequisites. So you have to comply with those things also.
Got it, sir.
But I would love, in case if you can send me like all the organizers, in case if you can ask. I'm sorry, who I was talking to. I can't see this.
Sir, this is Saurabh, sir, second year.
Okay, Saurabh. So, Saurabh, in case if you can send me whatever housing board thing you were discussing, you just send it to me through CADR only. You can email it to me, and I would love to read about it. And then obviously you can ask your query in the mail only, and I'll try to respond to it. Okay.
Exactly, sir. It was from the Maharashtra Housing Board Development Project.
Correct.
They have delayed it for 20 years.
See, there might be different situation also. It's not that way, but anyway, that is what I'm saying. That you send me to me, let me read it. Let me try to see what was the exact situation in that. However, in case if you say that a construction arbitration without a time limit, I have not seen it.
Sir, pardon me, sir. That I have by mistake said that there is no
No,
time
it's fine.
limit.
It's fine. Obviously, yeah. At least in second year, you have all this knowledge. I was a very dumb student when I was in second year, so I'm appreciating what all questions are coming up, and I am liking it more because going down the lane. Obviously, I love to answer more questions. So anyone has any doubt, any basic doubt also, please don't think like, oh, he's so senior or whatever. I'm just a student right now also. So you guys can ask me any lame question, any basic question as much as possible.
Yeah,
Okay.
sure.
Anyway, so next is variation claims. So variation, I've already told you that obviously if there is a difference between cement and bituminous cement example that I gave, that there was a variation of the work that has to be done, in that case variation come into play. Like for example, like in case if I had to construct a road with cement and it was for 10 rupees, now I have to construct a road with bituminous cement which cost 12 rupees. Therefore this 2 rupees come into play, and this is the claim which a party can ask from the employer. Correct? Now this is extension of time claim. Now this is very important in a construction arbitration, obviously, because EOT plays very important role, because obviously, I mean, it's not fixed that whatever time duration is given in the contract, the parties can complete the work. 99% never the work gets completed in that, but obviously there might be some cases wherein work gets completed within the stipulated time period. However, like in case if work is not getting completed, then the one of the party, like for example LNT, in our case LNT will say to NHAI, because of these reasons I'm unable to complete this work in this much time. Therefore please grant me extension of 30 days, 60 days, 90 days, whatever time period they want. Now NHAI would do, what NHAI would do is NHAI will go and see that letter, see how many days duration is being asked, assess the situation, see exactly who was the responsible for the delay, and then eventually grant extension of whatever duration they feel is correct. So this is basically extension of time. Correct? Now I move to employer and employee claim. For example, employer here is NHAI and employee here is LNT. So you guys please take this in that respect only. I think this is same, but still I'll go through it. Delay claim, this is employer scheme for NHAI. Obviously, in case timelines are not met, and in case if you, I mean, NHAI can say LNT, oh, you have to complete the work in 6 months. However, now we are sitting after 18 months, yet the road is not complete. So this is a delay. Therefore, employer might ask for a claim from LNT. Then, obviously, if LNT defect workmanship, if LNT works is not very quality oriented, so LNT, NHI can ask for a defect workmanship also. Then there's cost overrun. So, for example, in case LNT feels that their work was not very complete and the road is not being constructed, LNT goes off. Then NHA have to engage some other contractor in that case to complete the road. So, for example, it goes to Adani and says, "Yeah, please complete my road." So Adani will come up. Now what has happened is NHA has to pay LNT also for whatever work they have done, and now NHA has to pay Adani also. So these are basically extra costs which has to be bear by the NHA. Then there's a breach of contract. So, for example, NHI contract is saying XYZ things. However, LNT while working does something else. So there's a breach of contract, which obviously NHI can ask from NHI, LNT. Then there's the liquidated damages. This is very important. However, I would keep this topic aside right now, because obviously I don't know how many of people you will understand. But this is basically in very layman language. Like obviously NHAI will, for all the delay which has happened because of LNT, NHAI will say you have to pay me damages for it, and therefore they will ask for a liquidated damages. However, this liquidated damages in most of the contracts is a capped damage. So basically, like it might be like 0.2% of the entire contract price, 0.5% of the entire contract price. So it is a very capped damage which happens, and NHAI would be entitled to that capped amount only. So maximum of that capped amount. So this is how it works for an employer. Now when we come to an employee, so employee, what claims can they raise is non-payment or late payment. For example, in a EPC contract, for every milestone, the NHI has to pay LNT. Now NHI fails to pay in exact time, or maybe paid in a late time, or not pay at all. Then LNT has a claim of non-payment or late payment from NHI, stating that you have not paid me, or you have paid me delay. So obviously with this delay, you have to pay me interest for this. Then there is unilateral variation, like I told you, from cement to bituminous cement. L&T has a full right to claim for bituminous cement as well. Now there is a wrongful termination. Now L&T is performing his duty. He's coming to the site, working, and eventually one day they get a letter from NHA stating that from tomorrow onwards, don't come. We are terminating your contract. So L&T has a full right to claim damages from NHAI for all the manpower, machinery, or whatever resources they have put, and all the loss of profit claims that they want to have. Secondly is escalation and cost inflation. Look, for escalation basically means, like for example, cost of cement in 2000 was 10 rupees. Now in 2025, the cost of cement is 20 rupees. So basically the price has escalated from 10 rupees to 20 rupees. So these construction arbitration, what happens is, like obviously these are long duration projects. Like for example, it starts in 2013, goes off till 2020. So obviously the amount of the raw material doesn't remain the same, correct? So in that case, the amount increases and the L&T pays with an extra amount, and he is entitled to ask for an escalated amount later on when they ask for a claim. And then extension of time, I've already told you, like in case of delay happens, then L&T can go to contractor NHI and ask them, "Okay, please, for these delays, I want to have an extension of time so that at least later on you don't ask me for damages." And this extension of time, NHI will assist, and then they will grant extra time for L&T to complete the project. Any doubt in these employer and employee claims? Uh,
No, sir.
okay. Now we come to FIDIC. So contract and construction arbitration is done. Now what is FIDIC? So FIDIC is basically a type of a contract only, which I would say. And please, everyone, I would like to you guys to focus on what I've written also. So FIDIC is basically Federation International Desk Inquiry Councils, and this is basically an organization which was has an headquarters in Geneva in Switzerland. Now it was established in 1913, and what it does is, like, it promotes how to write a contract. And what happens is, obviously, because in case if parties offer FIDIC contract, then it has this normal standard template, and all the parties have to follow that template. And eventually, there's a standardization of the contract. Then every parties note which clauses are beneficial for each of them. So it's very, very, very collaborative approach of going forward for a construction project. So FIDIC is basically right now is increasing day by day, and we want to see. I'll tell you what are the golden principles of FIDIC now. Now, golden principle one: the duties, right, obligation, role, and responsibility of all contract parties must be generally implied in general condition and appropriate to the requirement of the project. So all the duties, right, and obligations of all the parties have to be written in a general condition. Now in contract also there are two types: general condition, special condition. In general condition, all these rights, duties, obligations have to be written for all the parties, and it is there in a FIDIC. So FIDIC is basically a template, okay, template of a contract, and parties, whosoever is being engaged in parties and whosoever offer FIDIC, they customize that template in their own form. However, the basic clauses remain the same. So therefore, their standardization also is remaining the same. However, the customization takes place in a very minor way. Now, FIDIC, because it's a template, so all the conditions are drafted very clearly and they are unambiguous. The dispute that we saw later, earlier in the slides, like because of the unambiguous clauses, the dispute arises. So FIDIC at least overcomes that particular problem. Now, the particular must not change and balance of risk reward allocation provided for in the general condition. Now, the third principle is all the risk and balance should be between the employer and the employee. Should not be like all the benefits are for employee and all the benefits are for employer. So it is like maintaining a balance between, like, two risk for NHAI, two risk for L&T, two normal things for NHAI, two normal things for L&T. So it is maintaining a balance between each other. All the time periods are very specifically mentioned in FIDIC. So the query which was raised by Saurabh, that in case if time period is not there, so in case if housing board would have followed FIDIC contract, then all the time periods would have been clearly mentioned in that FIDIC contract. So the FIDIC contract helps us in that. And then obviously, as I told you about dispute adjudication board, DAB. This is DAB. So FIDIC also plays a pivotal role wherein before arbitration they want to promote DAB, that the parties should go to dispute resolution board for at least trying to adjudicate the dispute beforehand and not come to arbitration also. Now, what are the importance of FIDICs? Obviously, as I told you, it's very standard form. Risk allocation is very equivalent to both the parties, and it's very professional. Like all the professional draft this contract, so it's very like all the clauses are very unambiguous and are very crystal clear. It follows ethical practices like to maintain the balance between the parties, and then it also has a knowledge sharing platform wherein parties get to learn also about a lot of things which the contract and clauses tell. Now, FIDIC contract and its uses. So these are standard contract forms, which I already told you. Defines the project participants' rights, benefits, responsibilities. Covers all the stages of a contract management, which includes planning, designing, procurement, construction, dispute resolution, and post-construction operations. Then it covers contract, like he's the manager in a FIDIC. So it covers all the aspect of that manager as well. And then it promotes the fair dealing, openness, and teamwork among the parties. Now, the important thing which I wanted to talk about is what are types of FIDIC. So now, as I told you that these are the templates. Okay, so these templates are in different types of books. So like there's FIDIC red book, yellow book, silver book, green book, and each book has its own things. Now, red book is for construction arbitration, which involves where employer provides the design and contractor executes that design. Like for example, NHA will say you have to construct the road in this way, and LNT will say, okay, I'll construct the road in this way. So this is FIDIC red book. FIDIC red, yellow book is where the contractor is responsible for design and construction both. So for example, NHI will just say that you have to complete the work from Delhi to Gurgaon. And LNT will say, okay, fine, I'll say how the road has to be constructed, I'll design the road, I'll construct it, I'll do everything. So FIDIC yellow book is that type. Now, FIDIC silver book is again a type of a contractor wherein contractor like LNT takes up the own responsibility. However, it is more for an EPC contract and turnkey projects like which are our higher stake. FIDIC green book is basically for small scale projects like very low value, very low stake comes into play. Now, FIDIC gold book where the contractor undertakes the design, construction, and eventually operation of the facility also. Like for example, LNT would say, okay, I'll design it, I'll construct it, and then eventually I'll operate that road also. So FIDIC gold book will come into play. Then there is some contract book. So I told you, like for example, LNT has constructing the road. So LNT is the contractor. However, LNT needs a steel barrigating. And for that steel barrigating, it engages JSW. So JSW will come as a subcontractor to it. So FIDIC subcontract will come into play wherein LNT is engaging a subcontractor. Then FIDIC Blue Book is basically for all the dredging works and all the reclamation works. And this is basically limited to one industry, which is known as the dredging industry. Then there's FIDIC White Book, which is more of a client consultancy type of a thing, which is not in respect of construction arbitration. This is more of work-oriented service contracts. And then their FIDIC White Books come. Anyone has any question FIDIC type of books? Is anyone has any questions?
So you mentioned dabs, right?
I'm sorry.
So you mentioned about dabs, right?
Yeah.
I had a question regarding that. Like in the Indian context where like dabs are not very common, right? How do the arbitrators reconcile the absence of dab decisions where the contractual requirements are not under FIDIC?
So DAB is not very prominent in India, I would say. I still say that DAB is a very conceptual based concept which is going on, and because it is a part of FIDIC, therefore DAB comes into play. So in any contract agreement where DAB is a part, and if the dispute is not being properly adjudicated by the DAB and the dispute goes to arbitration, then arbitration tribunal welcomes that DAB decision. It's basically comes as an expert to them, like an opinion to them or a review to them. I mean, not review, basically I would say like a second opinion to them, like what the DAB one person before them has decided on this issue. So they basically take it as an opinion. However, that decision is not final or binding. Obviously, in case if arbitration has begun, the arbitrators play a very pivotal role in whatever award they will say, that will be final and binding on the parties.
Understood, sir.
Anyone else has any doubts in type FIDIC? Mm, I guess no. Okay, anyway. So notices, this is a very important thing in FIDIC. I'll just quickly run through it. Notices is basically in clause 20.1. This is just an example which I'm giving you. So clause 21 of FIDIC says, like any contractor, in case if they face any difficulty or they want to raise any claim, then that claim has to be told to the employer within 28 days. And this is a very strict timeline which it says. Like for example, if the LNT, I mean anyhow, fails to notify NHI about their claim in 28 days, as per FIDIC, LNT loses its right to claim any forward. Indian law still is figuring out a solution to this, but in case if FIDIC comes into play, and in case if FIDIC is being adopted very prominently in India, then this issue is something which the court might have to decide. As of now, FIDIC is very less, therefore things are very light. However, in case if FIDIC clause has to be, I mean, interpreted by Indian courts. This is what I want to say. This is a loophole which I found in a FIDIC. Have you guys understood? I think yes. Now these are key case laws: Sangyong, Satluj, and Hindustan Petroleum. Sangyong basically talks about that in respect of public policy, in case if anyone wants to challenge an award, then that challenge of award should be so high that it should be like on the face of it, it should be very pivotal towards the Indian law. It should hit public policy. It should be it should be going against something of Indian law. So Sangyong talks about it. Then Sangyong also talks about that in case if there's a foreign award, then in that foreign award, as I told you, like in case a party is a foreign, or in case if a party is an international commercial arbitration, then the one of the ground of patent illegality goes off. This is also what Sangyong discussed. Next is Satluj, Jal Vidyut Limited, and Jai Prakash. Here it was like that the arbitrators are the master of the contracts. However, I mean, they cannot interpret the contract in their own way. So whatever contract is being written, that is full and final. So arbitrator are bound to follow that contract. Then there's Hindustan Petroleum versus Banu Construction. It says that all the awards that the arbitrator is writing must be very clear with proper reasoning of whatever they are writing. In case if there is lack of reasoning or the award is not very clear, then that can be challenged and might be set aside also by the different courts. Now this is last pre-arbitration case management. So basically, this is how we handle, like in case if a construction contract comes into for us and a construction arbitration case comes to us. So how we handle these things. So we first basically see what case is, then we see how the documents are being there. We ask for clients to give us the documents, we understand those documents, we read those documents, and then we have an initial case management conference, CMC, wherein we ask the clients to tell us what they want and what claims they want. In case if we are representing the respondent side, then we ask, like, for all the claims that the other side has raised, we ask what is the defense for them, and then eventually we collaborate between the document and the defense that strategy or the claim strategy that the client is telling, and then we go for the case specific directions wherein different issue wise things are being framed, and that the issue wise framed is either converted to statement of claim or either converted to statement of defense. Now, what there is a lot of document management, because obviously construction arbitration is a lot to read. Like there are a lot of documents involved in this, and a person who likes reading should go for construction arbitration. This is my advice. However, I mean, Obviously it has contractual documents, it has financial records, it has technical documents. So contractual documents are basically agreements, drawings, schedules. Then correspondences are basically letters, emails exchanged during the pendency of the project. Then financial record is all the payment made, all the all the certificates issued, all the invoices raised. Then technical documents are basically the test reports, like for example, for construction of a road. So obviously at what soil the road has to be constructed, that test report of that soil is there. Then what quality of products that are using, so quality certificates come into play. So these are the documents. Then witnesses are there. So there are financial witnesses, expert witnesses, and party representatives. And then these witnesses are being crossed. So factual witnesses are basically who are very expert in facts. Expert witness are those who are providing their technicalities. Like for example, in one of the thermal power plant case, we found we were like grateful for a foreign expert to come into play, like Mr. John Trudeau. He's an expert in thermal power plant energy. So we had hired him for providing him services for an expert in that particular case. So this is how, for a particular case, we appoint a proper expert for coming to us to give an opinion. And then obviously there are party individuals also. Then there are experts, like different experts on construction experts, which comes into play. Like for example, there's a delay expert. Like for all the delay happens, they go through a primavera software, and then eventually they decide which party delay are more, which party delay is less, and who is liable for more delays and who is liable for less delays. Then there are quantum experts who goes through all the payments, invoices, everything, and then they give on the cost part, like who is liable to pay whom and what amount. So these are quantum experts. Technical experts are there who suggest on how, what kind of project it is, like what was the quality of the project which was used. And these are mostly engineers and architects, because obviously this is a construction thing which we are going on. Legal experts are there who expertise in construction arbitrations. And eventually, I mean, legal experts are basically advocates only, because at the end of the day, we are the one who are assisting and guiding the arbitrary tribunal for all the assistance. Now this is the last slide, I think. Yeah. So recently, I mean, arbitration is being lessened down by the government, and because obviously of different factors. However, like what the discouragement has happened in arbitration is, like for example, Ministry of Finance has said that for all the cases which are exceeding 10 crores, arbitration should not be the first thing to go for. Then secondly, a different states have amended their own clauses from the contract, and they have removed arbitration, and they've asked the parties to go to direct court for going into arbitration, I mean, rather than going into arbitration. And then they are promoting mediation as a more proper settlement. Then that is the reason mediation bill comes into play. So these are the changes, wherein there's some, I mean, things which are against arbitration. However, I think arbitration still prevails and is still opted by a lot of parties, and it will continue to grow. I think that is it. Yeah. Anyone has any questions now? Okay, I'll stop stating now. Yeah. Yes. So my session is done, I guess.
Thank you so much, sir, for an insightful and enriching lecture. We truly appreciate the clarity with which you broke down the basics, the certain complexities of construction arbitration, as well as the FIDIC-based contracts. Now, moving forward to the most awaited part of today's session, the discussion on internship, specialization, and navigating life after law school. Something all of us are really eager to learn about. With your permission, sir, we would like to open the floor for questions. I encourage anyone who wishes to ask a question to first raise your hand. Once I take your name, you may unmute yourself, introduce yourself with your name, year of study, and then proceed with the question. So, beginning with the round, the first question comes from. Please raise your hand if you have any questions regarding. Okay, Saurav, you may ask the question to the sir, please. Unmute yourself. Am I audible, Saurabh?
Yes, sir. Am I audible?
Yes, you are.
So recently reading a journal where Delhi High Court has dismissed a petition where NHI has filed a substitution petition and actually go through a reconciliation and created a special purpose vehicle where it want to reduce its rates and it completely want to avoid going to the arbitration. And so the parties filed an appeal against the arbitral tribunal to the Delhi High Court, and Delhi High Court has rejected that NHI cannot create SPV and because the liability and other things is not disclosed to the other party, then its newly created NHI uh, will jeopardize the arbitration proceedings. So basically, sir, the question is in construction arbitration is this practice prevalent where the parties to an agreement create a special purpose vehicle to the union association to
I'm
take
so,
its payment
I'm so
business.
sorry, I can't hear you like properly. Can you just type your question? In case if that is possible, you can type your question. I can read your question and then I can answer it. Your voice is not clear; it's breaking down. Hmm. I don't know. In case
Well, then, can we have another question, Professor? Okay, so I had a question actually. So as you said it multiple times that you still, look at yourself as a student, which is amazing because life is about learnings. So what do you think was the biggest learning of your law school, and that each one of should, and learn from you basically because you are elder to us, you have graduated before, so you have a first-hand experience of the real world experiences and practicalities. So if you could, and enlighten about that.
in law school, so basically when I graduated, so obviously there was nothing. I mean, I was a very mediocre student, so I don't know. I mean there was no one to guide me also. But to you guys, I would suggest, like, see, books are fine. I mean, obviously academic should be strong. You should understand what law is. At least you should understand what basic concept of law is. But I won't expect, and no one expects anyone that you should understand, like you should remember Bear Act like in full go. So these are the small things. But yes, when you go for your internships, I would suggest, like, down the lane when you are in, like, in your third year, fourth year, fifth year. So obviously all the internships, like first, second year is still fine that you guys are still, I mean, young to enjoy your internships. But third, fourth, fifth year, I would suggest everyone to please be more serious and don't go and work as an intern. I mean, don't go and see, like, "Oh, okay, I'm here just for a month and then I'll go off and then, I mean, I'm in my own life." Try, I mean, what the best advice which I can give you is try to be loyal to a law, I mean, the place you are interning, or it might be any law chamber, it might be any law firm or whatever it is. Try to come back as an intern again and again with that same place. However, while you are interning at that place, try to work as an associate only. Like, try to work as a trainee associate or whatever it is. Just get into the nerves of the associate, senior associate, principal associate, so that at least they remember your name when you go out. And it should not be like you go, you work, you just do the research, go to court, and then eventually after a month you go off and then there's nothing in touch or nothing is that way. So what I would suggest is your internship should be your moving target, wherein you actually get to know what real work is. And trust me, real work and whatever is taught in law school is completely different. So once you come out of your law school and once you get into the real world, at that time the difficulty arises and then that time your struggle arises. And in case if your third, fourth, fifth year internships are pretty strong and you have basically articulated and learned at least small things, so your starting days of a fresher is are pretty easy. So I would suggest you enjoy your college a lot, because this time won't come. But then when you are in internships, don't just enjoy, like, you can enjoy post your office hours, but when you are internship, go to the nerves of your associate, senior associate, bosses, or whatever it is. Like, get into their nerves so that at least they will be like, oh my god, he was so curious to learn, or she was so enthusiastic for learning, that they will eventually give you something. And at the end of the day, I mean, in case if you want a job, I mean, in case if you want to go for judiciary, then that's a different thing. However, in case if you want to go for a job, then I would say this loyalty thing is very important. Like for example, if any ex-person comes and interns with Link Legal, like for example Dentons, so in case if they come in their fourth year, and in case if they come back in their fifth year, so obviously every law firm has this tendency of seeing, that is what callback internships are, wherein obviously the law firm sees and the partner sees, like, you that person is dwelling up into our team, he is understanding the environment, and therefore these are the small basic characteristics and nuances which you have to show to your partner, and eventually land up with something as a job pre-placement offer. This is what it is. So yeah, your internship should be your first goal to be very serious about.
Right, sir. So I had another question on the lines of what we just discussed, construction arbitration. So I believe that technology and basically AI is it's boosting, like going and disturbing each sector of the economy as well. How do you think that AI or the smart contracts, they affect construction arbitration? Do they have any challenges, or they disrupt anything of that sort?
No, see, I'm one kind of a lawyer who is completely against AI. Obviously, I mean, see, AI is fine. Obviously, taking job from engineers and everything, but I think law is one of the field wherein AI can't come up, because at the end of the day, lawyers have to be little critical about the arguments that they make, about the points that they discuss, about the brief that they make. I mean, AI is fine. They can improve your grammar, they can improve your vocabulary, they can enhance the sentences, they can improve the language. That's fine. And they can, I mean, they can draft a list of dates or whatever it is. But at the end of the day, it's the lawyer role who has to understand, interpret a document, which AI can't do. Number one. Number two, to all those, I mean, I as a lawyer always think like a very critical view, have a very critical view about understanding any document, understanding any clause. So obviously, these critical thinking about critical approach is very important, which I feel AI can't have. And these critical thinking is required when we frame an argument. So obviously, when we go and defend a client or fight for a client, so obviously we need to have that, out of break thing, out of something which is not very prominent, which a person can see. AI, it will, what AI will do in case if AI is the thing, and every party will come at a normal pace. And I mean, in earlier days is like when our senior advocates were practicing on all these small things, obviously the person who had a better interpretation of law, obviously the person who was more involved in law, always used to win the cases. This is what was happening. Now if AI comes into play, if I also upload a document, you also upload a document, and both can come up as an argument, then obviously everyone is equivalent now. So this is not how it works. I mean, obviously AI helps you to give first step, but at the end of the day, as a lawyer, you have to have a very critical approach of how you are making an argument, how you're presenting it before the court. That is also an art. So these are the small things which AI can't get into, and this is the thing which I feel that I mean, I'm privileged that I'm in a law field wherein AI can't step into my shoes, at least for some time. Let's see, until unless AI starts speaking in the court.
True indeed, sir. Even I was reading an article on it, and I came across a word that artificial intelligence should not be considered, as a replacement. It should only be an assistive tool, and that's it. It should not even thought as a, replacement towards a real skill that a person has. So indeed, true, sir. So let's take some more questions.
Sir, I just had a question. Like you previously stated that you come from an engineering background, so you have science in. Am I right?
No, no, I'm not an engineer. I did my 12th from science background. So
Yes,
even
yes.
I did when I did it was 2013 when I graduated. I mean, when I completed my 12th. So at that time, science, like, there was a boom of engineers coming up. So that was the thing. Like I said, that science background, it meant engineering. However, I choose law because I have a phobia of maths.
So, sir, like whether it somewhere helped you in the commercial arbitration, because it might require that expert's lens that might provide you, because you have coming from that science background. Like me, I'm coming from humanities background. So, like, it will be very much difficult for me if I am going to explore that area.
Not at all. Not at all. Because I'll suggest, I mean, I'll tell you honestly, 12th, what we study in 12th in physics, chemistry, bio is something very different from what we do in construction arbitration. Number one. Number two, construction arbitration, even I was not very, I mean, when I graduated, you still guys know what construction arbitration is. When I graduated, almost like after 2 years of practice, also I had no idea what construction arbitration is till 2020 when COVID struck. So at that time, when I joined Singh and Associates, like as a associate, at that time I got to know what construction arbitration is, and from that moment I started studying construction arbitration. So at that moment, when you sit with clients, when you understand their cases, when you speak to experts, when you speak to your seniors, so obviously these small concepts of construction arbitration you will get off. So there's nothing to worry about. You are free to go about it, and you can understand that construction arbitration irrespective of the fact. Like I told you, no, I leave my 12th, leave my law school, leave my 2 years of practice. Then I started with construction arbitration, yet I'm sitting here. So, I mean, this is how it goes. So, in case if you are very prominent and you want to do construction arbitration, so I would suggest, in which year are you, if I may ask?
So, I'm in my third year.
Okay, so you are in your third year, so I would suggest, in case if you really want to go for construction arbitration, then do third, fourth, fifth year with internships with respect of construction arbitration only. And trust me, 30-40% of construction arbitration will understand while doing internship only. So once you join any place in this field, it won't be very difficult for you. So don't worry about it.
Okay, sir. Thank you.
And
Can we have the next
Good
question,
evening, sir.
please? Please
Good
go
evening,
ahead with
sir.
the next.
yes,
Sir, this is Jayati, a third year law student at CNLU Patna. My question pertains to the enforcement of arbitral awards related to construction arbitration. So, in my internship time, what I've felt is that domestic arbitral awards with respect to construction arbitration or any other arbitration procedure, uh, most of the times those awards are not enforced by courts and they go into subsequent litigation or challenges. Now, the grounds under the Arbitration Act is very vivid with respect to challenging of domestic awards. But with respect to international awards, it's very limited. So most of the domestic awards, they do get challenged at a later stage in court. So the purpose of arbitration gets defeated ultimately. So do you have any suggestions as to any changes or amendments that we should have? Because after the 2016 amendment, the grounds have been very widened, like patent illegality, perversity, all those grounds have been added. So, with respect to international awards, the government agrees that they should be enforced and they should not get challenged because it's the portion of other country's jurisdiction. But for domestic, it gets on and on, it's never ending. So, do you have any suggestions or policy suggestions or amendments that you would suggest?
no, I think, I mean, see, for all the international commercial arbitration, talking about India, that's fine. But go a step prior. So, like, for example, a award which is passed in Singapore, for example, that award also, I mean, the provision of an appeal is always there. Like, for example, in case if you go for a court also, litigation, then in case if a high court orders, like a single bench orders a order, gives an order, then there's an appeal for a DB. In case if you don't understand the judgment of a DB, you can go to Supreme Court. So there's always a chance of an appeal until unless Supreme Court is the authority which says, okay, fine, this is the end. So Supreme Court, that is why it is known as the apex court. And in case it's you are talking about domestic and international award, domestic award, obviously because it's of India, therefore there's a provision for an appeal. An appeal will always come into play because there might be one of the party who is not very happy with the award passed. Obviously, every time the party who against whom the award is passed, they go against the challenge. In the international commercial arbitration also, enforcement is not happening, is happening because that enforcement is coming from challenge in their own country. So it's like there also the award is being challenged first. Once that award is being decided in that country, like for example, if award is passed in Singapore, then first the party will go to challenge that in Singapore High Court. Once that Singapore High Court that award will come to India for enforcement. So you are just seeing the enforcement side of the view that international commercial arbitrations are very easy for enforcement and everything. But you are not seeing the previous side of it, that it is also being challenged in Singapore first. So there also the stage comes of challenge. So this arbitration is very uniform across like Singapore, Hong Kong, London, wherever you go. The clause of challenging an award is prevailing in all these countries, and everywhere this happens. So I don't think so. Nothing anything can be changed in this, because obviously in cases are also very appeal oriented, and at the end of the day, everything goes to Supreme Court for final decision. So until unless the party loses all their hope and they loses all the interest, I think the party still survives with 1% hope that they have to win a case. So I think this is how Indian law will govern.
So, but that doesn't it actually lose the importance of what arbitration is meant for saving time and for saving money? Because the other party who's never going to be happy drags the case to the Supreme Court.
See
So, do
that
you think that the ground should be limited for domestic as well?
No, see, I've understood what your point is, and obviously that's a lacuna, and that is the reason that now ministry is like not very actively approaching promoting arbitration, and this is the reason that government has decided to go against arbitration as well. However, the point is, see, uh, it's still the same, because in high court also, if you file a civil suit or something, you have no clue that when the matter will be decided. At least in arbitration you have this thing clear that in 2 years, or might be max to max 3 years, your case will be decided, because it has to be decided by that time. In case if the tribunal is not able to decide the the award in three years, then that award can also be challenged and set aside. So that is also a different thing. So at least parties go for arbitration with just one hope, that at least in 2 3 years we will at least get an award, and at least we will see which side the award of which party is getting a very favorable order. Like for example, now in case if we file a civil suit in high court, like for example, now today also I went to high court, and now we have started getting dates of April. When the matter will come in April, they will give dates of September, October. Again, when the matter will come in September, October, they will give dates in January, Feb. So it's basically a entire case in a year. Max to max twice or thrice comes in a court also. So on every case also, I believe, minimum 5 to 6, 7, 8 hearings happen. So it is also stretching across a lot of time period, and then obviously there's a provision for appeal. So in that also case, again the appeal will go. Then the single bench appeal, DB appeal, Supreme Court appeal. At least in arbitration, once the award comes, then you have to go to 34, and if 34 does not happen, then you have to go to Supreme Court. At least it's just 2 steps. In civil suit and in different suits, obviously there are a lot of things that comes into play. So parties are still thinking from that approach, that at least in arbitration you'll get a first view. Might be possible there are a lot of things like in arbitration. What I'll suggest, what happens basically is, and this is how real function happens. Like once arbitration award comes, so a lot of times you will see parties who is at a losing end, they approach the winning side for settlement. So they will say, okay, fine, this is the award. Like for example, 10 rupees have been asked. I'll give you for 8 rupees. Let's settle it and let's close all the litigation. Other side will also say, okay, fine, yeah, ठीक है, these are the exaggerated claims. 8 rupees मिल रहा है. That's also fine. Let's close this. So arbitration works in this way. So in 2 years, at least you'll get 8 rupees and this gone. No more litigation. For those parties who want to be like fully justified and have full justice, they only have a different opinion, and that is a long time taking process. So this is how arbitration also works.
Thank you, sir, for
I hope
giving
I
us.
have answered your query in a very
Yes, sir. Sir. Yes, sir. Thank you.
Can we have another question, please?
So, I'm Yashi, a third year law student. As interns, we often hear a lot about how fast paced and chaotic the corporate world can feel when we first step into it. So, sir, if you had to give us just one real cheat code for surviving law firm life without losing our sanity, what would it be?
Um, I would say, come to office and just work. Don't get into office politics. Don't get into gossip sessions and everything. Once you complete your task, every partner needs a associate or a resource, basically, I would say, who comes and delivers its work and then goes off. So, in case if you are delivering your work in time, then I think your life will not be very difficult. But yes, in case if you are not able to deliver your time, I mean work in time, at that time situation might arise. But this is what I'm talking about litigation. When we talk about the corporate side of law, obviously they have their transaction and everything. So in that area also, I mean, when there's a transaction dates going on, so there's a lot of pressure which comes into play. So you have to first decide which field you want to get into. I have little less knowledge about the corporate side of the law firms because I have always been practicing in litigation. And litigation, I mean, we do have heavy days. Like I have been part of my journey, like wherein for 2 days I've been in office for work. I've not gone home also for 2 days. And I was staying in office, I slept in office, I wake up in office, I change my clothes, everything in office. So for 2 days I've been in office. So I mean there are days when things get little difficult, but then there are days when things are little light also. You get your weekends. But yes, you should be honest to work and diligent towards work. So if you are sticking to your timelines, I don't think so it will be a problem. But then that's up to you how you are going about it. I hope I have answered your question, but in case if you have a follow up, you can ask me that also.
No, sir, thank you so much. This was genuinely valuable for someone at our stage, and I really appreciate the clarity and the practical advice that you gave.
But I would suggest being in third year. I mean, because obviously a lot of people are from third year, so I would suggest uh, this is the last year of enjoyment. I mean, being very honest. For fourth year and fifth year, please, once you step into fourth year, fifth year, take your internships very seriously and try to be as loyal as possible to the firm where you are interning, so that at least you get a call back, and then eventually you trust build. I mean, win the trust of the associates or seniors you are working with, so that eventually when you get out of your law school, they can help you with something in hand. I mean, this is the thing which I was not told, otherwise I would have been in a very better position. And yes, one thing which I want to talk about to you all, no one is asking me, but I'll say, don't try to get names of different law firms in your CV. Try to be, this is what I say, try to be loyal towards one place. In case if that place is not offering something, that's a different thing altogether. But just don't jump on from one law firm to other or one office from other, so that you can show in your CV, oh, I have done it 10 places. No one really matters. All that matters is what work do you know. So, in case if you are getting expertise in arbitration law, stick to arbitration teams of different law firms. Try to stick to one team, one office only. In case if that is not possible, then stick to at least subject. First, stick to office. If not office, then stick to subject. And if not subject, then obviously whatever it is happening. But that's a plan. So, for example, if you're going for arbitration, for example, you are going for general litigation, for example, you are going for corporate side like capital market, for like mergers and acquisition, so for like IPR, for taxation, indirect, direct. So whatever field you want to get into, third year is this time when you have to decide which field you want to get into, which is the area that you want to get into. Keep your fourth year, fifth year internships specifically for that office or specifically for that subject area, so that when you graduate, you at least have a basic idea and you don't graduate as a freshers, you graduate as A1. So this is how every partner wants. So this is how every like I being a senior associate, I would prefer like a person who is having a knowledge about construction arbitration come in my team. A candidate who is like a bilkul fresher and the candidate who has done internships in construction arbitration understands basic words of construction arbitration. I would prefer that candidate over the person who is a candidate. So this is how you have to show, and this is how you have to plan your strategy once you are in your fourth year interview.
Thank you, sir. Is there any more question which would be like to be asked from sir? This shall be the last question. I'm assuming there are none. Thank you so much, sir, for your time. It was truly wonderful to have you with us today. Your insights on construction arbitration, FIDIC contracts, and career building have truly enriched us. And I'm certain that all of us who are walking away from here today after this session have something valuable learning today. We genuinely hope that you had a great time interacting with us as well.
Yeah, obviously. I mean, session was scheduled for 1 hour. We are ending in 2 hours. I think that shows how positive it is. And also, thank you to you. Thank you to Yash. Thank you to. I mean, I don't know whether you guys know Charlene. He is interning with Link Legal right now. So I wanted to thank both of them. And eventually, I just want to say, like, in case if anyone has any doubts about the career, also you guys are free to approach me on LinkedIn anytime. I'll be happy to help CNLU students. Don't worry.
Thank you so much, sir. As we conclude this session, I would request all the attendees to fill up the feedback form. It's in the chat box and will also be circulated in your respective groups. Thank you, everyone, for being here. You may leave the meeting now. Have a wonderful day ahead. Thank you.
Thank you.